This is Dr. J. Kent Gregory, and welcome to part two of chapter two, the court system. Let's first start our discussion, or this part of the discussion, with the difference between judicial conservatives and judicial activists. So, judicial conservatives, also known as originalists or strict constructionalists, believe that the Constitution should be interpreted strictly in light of its original meaning when it was written. And this is from their perspective in the courts. This is what the courts only should do. They believe that change, societal change, especially the creation of new civil rights, should come from the political process, meaning through the legislature, rather than the judicial process. So change comes through laws or the legal process, not through their interpretation, not interpretation. Uh, okay, so judicial liberals, also known as judicial activists, believe that judges do have a role to play in shaping a more perfect union. They believe that the outcome of a case is paramount over other considerations, including past precedent. So judicial activists are more likely to find new civil rights in the Constitution, which they believe should be broadly interpreted in light of modern society's needs. So the modern fight over judicial conservatives and judicial liberals began with FDR's New Deal during uh, uh, the during his time in office during the Great Depression, and his court packing plan continues to this day. Uh, the right to privacy is a good example of the difference between judicial conservatives and judicial liberals. And it is seen as a test to determine what philosophy a judge subscribes to. So this is a very important key takeaway. Uh, so some procedures. There's civil procedures. These are rules governing litigation in civil cases. Most often, that's what we'll encounter in business. Criminal procedure. This is rules governing litigation in criminal cases. And the United States has 51 separate legal systems, so one federal and 50 in the states. Here's a good outline or a tree, if you will, of hierarchy of the state and federal courts. So at the top, you have the Supreme Court. And on this side, you have the United States District Courts. So there are 94 of those. These are federal. So federal over here. And above them are the U.S. Courts of Appeal. There are 13 of these, 13 circuit courts, and they go to the Supreme Court. State trial courts, so this is state, and then the intermediate appellate courts, and then the state Supreme Courts. And then above them sits the Supreme Court of the United States. So a key takeaway here is that the 51 separate legal systems in the United States each has its own executive, legislative, and judicial functions. State constitutions remain a vibrant source of civil rights protections for many citizens because state constitutions are permitted to grant more civil rights, but not less, than the federal constitution. So subject matter jurisdiction is the authority of a court to hear a case based on subject matter. State law claims are generally held in state courts, while federal questions are generally held in the federal court. Federal courts do sometimes hear state laws under diversity jurisdiction. Federal cases are filed in a U.S. District Court and appealed to a U.S. Circuit Court of Appeals. State cases are typically filed at a trial court, appealed to an intermediate court of appeals, and then the U.S. Supreme Court is the highest court in the country, and all other courts must follow the precedent in Supreme Court opinions. Trial courts are the triers in fact, and their judgment is not questioned by the appellate courts. Appellate court review is simply limited to legal errors. So appeals, as the book points out, tend to fail unless they find uh, legal errors. That's their job. Here's a nice map of the geography of the federal courts. So you have the first up here in Maine, which also includes Puerto Rico. So I suppose that would be a nice vacation for those judges. And then the Virgin Islands are here in the third. One thing that's interesting is you typically start you do start in the east and you flow west in terms of the number of the district courts. But the fifth district court in the 80s, the fifth district court in the 80s was, because it was so large, was separated between the fifth and the 11th. So that's why you get the 11th kind of sitting way out here. And that wraps it up. Hope that was educational. Hope you enjoyed that.